My name is John Haley. I'd like to welcome you to another in the series on law and business in East Asia of the Asian Law Program here at the University of Washington. My guest today is Professor Sang-Hyun Song of Seoul National University. Professor Song is one of Korea's leading legal scholars. He has degrees from Seoul National University, studied at Cambridge, has a doctorate in law from Cornell Law School. He has taught in the United States at a variety of law schools, including the Harvard Law School, the University of Florida, New York University Law School, and is currently here at the University of Washington as a visiting professor. Professor Song has written very widely on a multitude of subjects on Korean law in English, as of course in Korean. He is one of the most respected and best-known members of his faculty and one of the best-known legal scholars in Korea. Today I've asked Professor Song to come to talk about technology transfer agreements to Korea. And let me begin first, Professor Song, by welcome you to this series. And let me begin with the question, for an American business person who is interested in licensing or transferring technology to Korea, what are some of the most important considerations that they should keep in mind?
Well, there are a number of things to consider. First of all, this is the legal aspect. Many technology providers in this country might be afraid that lots of piracy or intellectual property infringement are going on in Korea. So what am I going to do when the technology, high technology I provided to Korea is violated and so on? Well, with that respect, Korea has a whole range of very modernized intellectual property laws, ranging from the Patent Act down to Trade Secret Protection Act. Of course, I'm well aware that it's one thing to have a modernized legislation, and it's quite another to enforce them as they should be enforced. And over the years, Korean government as well as business sectors have been diligently educating the general public and enforcing the violations and cracking down all these violations as much as possible. And recently, Koreans are beginning to realize they too are victims of this intellectual property violations. As a result of massive investment, our own investment in the R&D, we are beginning to have our own patents and inventions and designs and trademarks and so on. And we realize that they are being violated by the third world countries. So that kind of changes and of situations and growing awareness of the value of the intellectual property on our part change our traditional attitude for better protection of the intellectual property. So as time goes by, I'm sure the fear harbored by the American technology providers will perhaps disappear.
In terms of a technology transfer, say the American has chosen to license either know-how or patent rights to a Korean firm, what types of restrictions on the use of the technology after termination, or restrictions on reverse engineering or on sales territory, on exports, are permitted under Korean law?
Well, that's antitrust antitrust law-related consideration for technology licensing. Well, for technology licensing, we have the legal framework provided by the Foreign Capital Inducement Act. And when, well, the foreign technology providers, of course, can freely negotiate all the terms and conditions of their technology licensing agreement. Although there is a standard technology licensing agreement for your convenience, but you can deviate from this standard contract as much as you want. And when you sit down at the negotiation table, there are a set of guidelines promulgated by the Fair Trade Commission, which deals with all the concerns you just mentioned. So these guidelines specifically provide for, what kind of provisions would be, in violation of our own Anti-Monopoly and Fair Trade Act, and what are not, and so on. This particular guidelines provide for even the definitions and scopes of technology licensing you are talking about, and all kinds of antitrust considerations there. So in most cases, it would suffice for you to follow these guidelines. Yet, when you actually deal with a Korean licensee, there's an interesting difference of perhaps notions. From Korean viewpoint, the Korean licensees tend to think licensing as a kind of sale of technology rather than lease of the technology. So when they are asked to return the technology upon expiration of this licensing period, they are somehow puzzled to understand what that would mean, you see. So you would probably have to make clear from the beginning on this point, then that would be all right. Otherwise, because of the difference of understanding with that respect, it's kind of dispute might arise.
You mentioned two pieces of legislation. The first was the Foreign Capital Inducement Act, and the second, the Anti-Monopoly and Fair Trade Act. Mm-hmm. Are these the only two statutes that relate to foreign technology licensing or technology transfers to Korea?
Well, strictly legally speaking, there are two more legal channels through which foreign technology can be introduced to Korea. The second channel can be found under the Foreign Exchange Control Act. Under this particular, well, we could introduce trademark licensing or other types of licensing agreement under the Foreign Exchange Control Act if this whole licensing package doesn't require any outbound payment in hard currency, or the total amount of royalty or other fees payment do not exceed certain levels, then it's pro forma, very automatic. And the third channel can be found under the Technical Services Business Promotion Act. And under this particular law, certain technology of perhaps very important technology for certain vital industries can be introduced through this channel, and then in this case the responsible ministry is not the Ministry of Finance and Economy, but Ministry of Science and Technology. Yet these two channels I just mentioned are rather rarely used.
In the case of technology which is not protected by patent or copyright, is there any legal protection available to the foreign holder of that technology?
Oh, I think when the Foreign Capital Inducement Act defines the technologies to be induced, it doesn't necessarily limit itself to just patented technology. It does include technical know-how, unpatented technical know-how. So when we talk about technology licensing under the Foreign Capital Inducement Law, it does include unpatented technical know-hows. And also we have Trade Secret Protection Act. So you could protect your technology under the Foreign Capital Inducement Act and other intellectual property law regime on top of this Trade Secret Protection Act.
Now, the Unfair Business Practice Act is this a new statute that protects trade secrets, or has this been recently amended or changed?
Yes, the protection of the trade secret is included in the Unfair Competition Prevention Act in 1991. So it's rather new. As you know, this concept of trade secret is not very well known in the civil law jurisdictions. See, we thought we could protect trade secret, if any, by contract or by the tort law in the civil code, but we had to legislate a new piece in 1992.
And these new statutes or their amendments seem, I think, from an American lawyer's point of view or a business person's point of view, to be quite unusual. But from a European or a Japanese or other civil law jurisdiction point of view, how unusual are these statutes? Are they peculiar to Korea, or do they have some particular features that are only found in Korea, or are they generally harmonized with other European or other East Asian country systems?
Well, you see, the harmonization of the intellectual property law is quite a formidable task, but we should keep working on this for harmony. And especially after we signed the WTO agreement, which has the TRIPS agreement in it, domestically Korea reflected all this ideas or provisions in the TRIPS agreement on our national legislation. So even when we first enacted all this new intellectual property law, we try very hard to conform to the the internationally known standard and levels of protection and internationally known requirements and so on. And on top of that, as I said just now, we just underwent another round of amendment to adopt all the provisions in the TRIPS agreement. So it's not uniquely Korean or anything. It's it's pretty common.
In terms of Korean attitudes toward technology, you mentioned that a Korean firm that is interested in receiving foreign technology may think of a license as if it were a sale. Are there other social attitudes that are important for a business person to keep in mind? For example, how important is the commercial or long-term business relationship, concerns over trust between the partners that has to develop over a long period of time?
Well, I would perhaps rather generalize I would want to give rather generalized answer to your question. Just like in many parts of Asia, you see, to sign a contract is one thing, and it's quite another whether this whole contractual arrangement would be, closely complied with. So it's, but it's very important to develop a personal relationship with the local partner, and then, well, to develop some sort of personal trust between for the business, and then that way perhaps you could perhaps carry out the business more smoothly.
Are there other considerations that you think a foreign holder of technology should keep in mind in planning a venture or a project involving a transfer to Korea?
Well, at the moment, the people's attitude toward technology or other intellectual creation has been rapidly changing. So, even if a kind of violation takes place at your workplace, you could perhaps, you could approach the other side, by rather than just taking the case immediately to court, but just talking.
Now, in terms of taking cases to court, I understand that it would be, it's considered to be an unfair practice under Korean anti-monopoly law to include a dispute resolution clause that would require the parties to litigate in the home jurisdiction of the licensor. That is, to require, for example, the Korean licensee to be subject to U.S. court jurisdiction. And the preference then would be an arbitration clause in a third country.
That's right.
Am I correct?
Yes. So I've seen many technology licensing agreements that do have arbitration clause. Most of the technology license agreement I have reviewed do have arbitration clause. with governing law clause, that says the governing law is the Korean law. Arbitration, is not necessarily required to take place in Korea. You can perhaps submit the case to the ICC arbitration or elsewhere. That's quite all right.
Now, I know you've had extensive experience with arbitration. Do you usually advise Korean parties or foreign parties to choose arbitration over a choice of court clause in the contract?
Definitely. If you agree to litigate your dispute in the local jurisdiction in particular, say in the Korean court, in terms of time that it takes, and in terms of the financial resources that you have to spend, Korean court procedure is not terribly bad. It's rather comparatively speedy and inexpensive. Yet it might be quite possible to, it's hard to get any, say, patent expert who could give you expert testimony, or I don't think it holds true now, but until some years ago, some of the young judges tended to show rather, nationalistic
I see.
attitude toward this kind of disputes. Well, that was one of the points raised by the American Chamber of Commerce in Korea. So I just, without any doubt, I prefer arbitration to litigation for technology licensing dispute.
Thank you very much for joining us today.
Thank you very much.
We can sit here for